versus Mahoney.
You got a big rubber band down there somewhere. Next time.
Mr. McGallagher.
Thank you and good morning, Madam Chief Justice, and may it please the Court. My name is Neil McGarrigan. I am here today on behalf of the plaintiff appellant Rasheed. The principal issue presented by this case is whether the inmate's claims under the Massachusetts Declaration of Rights are subject to and entitled to strict scrutiny review rather than the less stringent and more deferential Turner standard applicable to federal constitutional claims.
An inmate's claim of religious freedom or exercise.
That's right, Your Honor.
Weren't you here a couple months ago on one?
Yes, Your Honor, I was.
What's happened to that one?
To my knowledge, Your Honor, nothing has happened since. That was September.
And the issues were remarkably similar, weren't they?
There are many overlaps. Principally, this religion claim. Both cases do present issues.
A religion claim.
Right.
Were you arguing for strict scrutiny in that one, too?
Yes, Your Honor.
Okay. And they were arguing for Turner.
That's correct, Your Honor.
Okay.
And I think the analysis starts directly with a look at the Declaration of Rights. And Article 46, Section 4 specifically extends the protection for free exercise of religion
To everybody.
to inmates, specifically to inmates. It mentions inmates of penal institutions. This, of course, is a distinction from the federal Constitution, which doesn't mention inmates, doesn't mention prisons, and doesn't purport to set a standard for inmates that is concomitant with the standard that applies to all of the rest of the citizens of the Commonwealth. So on that basis alone, there is a very compelling reason to treat inmate claims under the Declaration of Rights concerning religion differently than religion claims under the federal Constitution. And I would point out as well, focusing still on that very same provision of the Declaration of Rights, the precise language applies to any inmate of a publicly controlled reformatory, penal, or charitable institution. To extract from that grouping of three inmates of penal institutions and treat them differently, i.e. to treat them under the Turner deferential standard, but to not apply that same standard to inmates of, for example, charitable institutions, would undo the protections of this clause. So I think looking directly at this clause of the Declaration of Rights, there are two principal reasons to treat inmate claims under the Declaration of Rights differently. First of all, it says right there, inmates are protected. Secondly, there wouldn't be a basis for treating them differently from the other two categories of people that are included in that same clause. And for those reasons, Turner v. Safely doesn't apply under this situation at all.
So would there be any circumstance where a person running a jail or a prison could say to an inmate, look, you can't have any of these things, or you can have them in a reduced way or a different way? Is it just wide open?
No, it's not wide open, Your Honor.
I mean, if it's a safety issue, I assume you'd agree they could do it?
The standard that would apply is that the state would need to show a compelling interest and that the restriction is narrowly tailored to serve that interest. And I think there's not any argument here that institutional security and safety of inmates and guards is anything other than a compelling interest. So where issues concerning safety and security are implicated, the department would simply need to show that the restriction is narrowly tailored to serve that end. So it's not an unlimited...
Well, they've made some of those assertions here with regard to some of these items, have they not? The powder, for example, they claim could be used to perpetrate an assault and so on.
They have
high drugs and so on.
They have made some of the assertions. That's true, Your Honor. But I think the salient fact is that for 25 years, they allowed Mr. Rasheed to have every one of the items that are have been taken away from him since 2000. So from 1975 until the year 2000, Mr. Rasheed was entitled to possess in his cell each one of these
Well, he was in a
items.
different institution, though, wasn't he?
He was in two different institutions. He's presently, I believe, this started at SBCC, Sousa Baranowski, and I believe today he's at Cedar Junction. So they are two separate institutions. But the fact remains
So
that
what you're saying is he was allowed to have these items and do what you're asking us to say he can continue to do. He was allowed to do that until he got to Cedar Junction. Is that?
Your Honor, I'm sorry, I don't know if it corresponds exactly with his transfer to Cedar Junction. I don't believe that it does. I believe that that the items were revoked prior to his transfer to Cedar Junction. There was a memorandum issued and directive issued by Commissioner Maloney, one of the defendants, and I believe the year 2000, that effectively revoked all of these religious accommodations and changed the department's policy with respect to religious items and articles that inmates were permitted to have in their possession.
As to all prisons or as to high security, like Cedar Junction?
Your Honor, I believe it applies to specific levels of security. In other words, I think the rules are different depending on the level of security.
Well, that would make sense, because as you get yourself into a higher form of security, it could be more expected that your privileges, whether they be religious or otherwise, might be curtailed for obvious reasons.
I think that's right, Your Honor, and that would feed into the compelling interest standard and certainly would feed into whether the department's restrictions were tailored to meeting the particular security concerns of a level 6 facility versus a level 3 facility.
But what is
for
the
example.
level of security at Sousa Baranowski?
The same as Cedar
Same as-
Junction, as I understand it, Your Honor. They're both maximum security.
So, for example, he had been allowed to have a relationship with a vendor to bring to purchase the foods from the private vendor.
Correct, Your
And
Honor.
now he can't do that anymore, and now he wants to be able to do that again.
He would be happy being able to do that again. He would be happy if the department were to use its own vendor to provide the food. And it's interesting that the department's brief points out that they have the food available through their own vendor. They know it's available, but they don't want to provide it. And administrative convenience, I think, is exactly what we're trying to get at here in terms of figuring out what's not a permissible interest when you're talking about a compelling state interest standard. Administrative convenience can't be the justification for imposing restrictions on an inmate's religion where the standard is a compelling state interest.
One thing, though, I wasn't clear on from the briefs. Does his religion demand or require all these things, or is it just in regard to at least some of the items that he believes his religion requires?
I think it's a fair statement that Mr. Rasheed believes that he sincerely believes that his religion requires him to do these things.
Well, is the question what the religion requires or what the individual believes? I mean, suppose somebody believes that their religion requires Santa Claus to visit them once a year. I mean,
Well,
they sincerely believe that.
I think that the person would have to demonstrate religiously founded belief.
We don't get into examining what religions require, correct?
But as a general proposition, courts do not distinguish between what particular adherents of a faith may believe versus other adherents of the
That
same
is
faith. It's an assessment that the courts are not able to make.
Yeah, putting it a little differently, though, perhaps, did the correction system have anyone from his religion in the position of authority, maybe it's called an inman, I don't know, who passed judgment on these things and said, no, what you're giving him is perfectly adequate under his religion?
I don't know if
I thought we heard some of that in
made.
the other case a couple of months ago, that they had retained these kinds of religious officials in different religions to say, you can give this as a substitute for that and all that kind of stuff.
It's true. In fact, I believe that there's testimony from two separate Islamic experts, both of whom may be imams. One is Omar Basma and the other is Ibrahim.
And what did they say?
Rahim. Ibrahim Rahim, interestingly, says if you take prayer oil, for instance, away from a Muslim, that's a substantial burden on the Muslim's religion. He also says if you take away a prayer towel, or a prayer rug, rather, that's a substantial burden on a Muslim's
But
religion.
did he say that the amount of prayer oil and the substitute for the rug, in this case, were adequate? Did he say anything about that?
I don't know if he addressed the rug, but Omar Basma did address the rug. He said if you take a prayer towel and you mix it up with the rest of the towels, which is what happens in the general laundry, it imparts impurities to the towel that renders that towel improper for use as a prayer rug. So you combine that with Mr. Rahim's statement that you take a prayer rug away and that's a substantial burden, and you've established a substantial burden. You also have, I think, pretty clearly on the facts, Mr. Rasheed's statement that the prayer towel is too small to accommodate him. He's evidently substantially taller than I am at 6'5" or so, with size 18 feet. He's an
18
enormous
feet?
Yes, he's an enormous man. And he doesn't fit on the prayer towel. He fit on his prayer rug. I don't think there's any dispute that the use of a prayer rug and prayer oil are very important components of the prayer ritual for a Muslim. And the prayer ritual is what this is all about. And
Now,
in
turning
fact,
to the oil for a minute,
Yes, sir.
he was getting a quantity of oil, was he not? 1 ounce or something?
I believe it's 1 ounce every 3 months is
Right.
the allotment. And
Was there any evidence that that was inadequate?
well, his testimony in his verified complaint and in his affidavit, I believe, is that he had enough oil prior to these restrictions going into place, and that he doesn't have enough oil
What about
now.
from either of the experts?
Mr. Rahim testifies, and, Your Honor, I don't know if it's part of this record or if I'm confusing it with the other record. I think it might be the other record, but Mr. Rahim says he can't make an ounce last 3 months.
And
I'm sorry, I take that back. Not that he can't make it last 3 months, but using it ordinarily, it might not last in 3 months. It might last only 1 or 2 months.
And am I correct that he also says that he doesn't want to have to stand during the counts because that's his prayer time?
That's correct, Your Honor.
But am I correct that it takes about 3 minutes to pray?
I think that's what
I'm just curious why he couldn't do his prayer after the counts.
his verified testimony is that he believes he is required to pray at 5 specific times of the day, and that 3 of them conflict with the standing count times. And I don't know if the standing count times vary from time to time so that it occasionally conflicts or if it always conflicts. But there are times when Mr. Rasheed is forced to stand up during a time that he believes he's obligated to be praying towards Mecca. And I think
But if half the people in the prison practiced this same faith and they were praying during count time would become meaningless. Isn't that true?
I don't know that it would become meaningless, and there are a couple of reasons why. The department, it seems to me, is able to do its count times at times that don't conflict with obligatory prayer times. So, in other words, and this was the point I was just about to get to, I don't think it's fair to judge it whether or not Mr. Rasheed rather, could do something differently. I think that the inquiry is whether the requirement that he get up while he's in the middle of a prayer is a burden on his religion.
Mr. McGalligan, can I ask you this? If we agree with you that the standard is strict scrutiny, do we have to get into going through the record and figuring out every one of these things, or do we send it back to the Superior Court to apply the correct standard?
Well, I think, Your Honor, that there is enough record support to make the determination as a matter of law that the defendants haven't made a compelling interest standard. You have two sides to this. The defendants say we have security interests, and they name some.
Well, I'm just looking at the judge's order. There's no evidence before the court to warrant the conclusion that DOC policies with respect to these, mentioning some items, have imposed any significant burden on Mr. Rasheed's ability to exercise his religion. And do you say that that's just a factual error?
Well, I think it's more. It might be even more of a legal error because the court engaged in this exercise of trying to determine whether these practices were central tenets of the religion, and that's
Correct.
the incorrect standard. So,
No, I'm-
Why is that the incorrect standard, though, when we have to determine whether the burden is substantial as opposed to simply incidental? You sort of have to know what's being burdened. What is the thing that's being burdened?
well, I think the answer is this. In the first instance, it's whether the inmate is exercising a sincerely held religious belief. And the department doesn't challenge that these are sincerely held religion beliefs. They've conceded that Mr. Rasheed sincerely believes that these are these are religiously required things for him to do. Their comebacker is,
So we look at whether they are substantially interfered with, those things or the exercise of his religion.
well, the exercise of his religion, but I think it's probably inextricably intertwined with those things, because those things are the way he prays. These are the aspects of prayer: being clean-shaven, being clean in general, having to wash his feet up to his ankles and his arms up to here, and having to wash around his face, having to apply prayer oil, having to remain apart from the impure floors. These are all part of the prayer ritual that are required.
Isn't this exactly why the Turner versus Safley standard has to apply into prison settings? I mean, this could get really quite crazy to try to run an institution with 30 or 40 different religions of various sorts, and everyone having their own views of what's required within whatever religion they choose. To try to run an institution in that environment that's secure, that provides security not only for the public but for the other inmates, isn't this exactly why the Turner versus Safley standard has got to be the standard applied?
I don't think so, Your Honor. And I know that the Court has determined that Turner v. Safley applies to certain claims under the Declaration of Rights, but I would respectfully suggest that the claims at issue in those cases, and I'm thinking in particular of Empapac and Casiccio, if I'm saying it right, were different constitutional
claims.
rights. You're talking
did
about
not involve the specific language of the religion provision.
That's exactly right. So if you're looking at what the Constitution in the Commonwealth requires, it's right on the face of the Constitution that inmates are entitled to practice their religion like everybody else. And I think that distinguishes those cases right off the bat. You also can look at the very distinct nature and essence of those different claims. First Amendment claims, especially the ones in Empapac, the petitioners there wanted to be able to form a political action committee that had as its purpose fomenting divisiveness and effecting regime change. That's fundamentally inconsistent with running a prison. Religion, on the other hand, is not fundamentally inconsistent with running a prison. And maybe I can close, if the Court has no more questions, with a reference to the amicus brief that makes the point that inmates who are entitled and allowed to practice their religion are actually safer inmates and contribute to prison safety. And there is a lower rate of recidivism among inmates who have been permitted to practice their religious beliefs. Are there other questions?
Thank you, Mr. McGowan.
Thank you.
Mr. McFarland.
Good morning. May it please the Court. Richard McFarland on behalf of defendants Michael Maloney and John Marshall.
Was this, refresh my memory, was this argument made in the other case as well?
Similar arguments. We had more of a qualified immunity argument last time, since that case did not involve
But did it involve a claim that strict scrutiny has to apply to religious practices?
Yes, Your Honor.
But we could have resolved the case in a manner that was not, we would not be required to reach the issue, correct?
Correct. But we believe, Your Honor, that
Because here it's not possible. We have to reach the question,
Right.
correct?
because the lower court had a much more detailed opinion in this case, and is definitely
The lower court specifically reached this issue.
Correct.
It was determinative, and it's before us in a more fuller fashion.
And she rejected specifically the strict scrutiny standard for this case. She relied on this Court's well-established precedence of applying the more deferential standard.
But not with respect to religious claims.
Well, true, Your Honor, but we're talking about correctional policies.
No, we're talking about the Massachusetts Constitution.
Incorrect, Your Honor. And this Court is also, in the MCAP case, in Casiccio, has applied the least restrictive standard to claims under Articles 1, 16, 19, 12.
Did any of those articles specifically mention inmates?
No, they did not, Your Honor.
Okay, so and you're saying that makes no difference?
Well, I believe, Your Honor, we would also look at Chapter 127, Section 88, which specifically provides the legislature inmates have a free exercise right, but that right is to be countenanced, to be counterbalanced by so as not to impair the ability.
The statute is perfectly plain. I'm talking about the Constitution.
And, Your Honor, I would argue also that when my brother mentioned Section 4 of Article 146, that was done a number of years after the amendment to General Laws 127, Section 88, which clearly provides for a deferential standard.
Yeah, can you refresh my memory from the other case? I think you told us roughly how many religions have to be accommodated, if that's the right word.
Well,
in the prisons, it was some astounding number,
Well,
like
the
20?
handbook itself provides, I think, 15 or 20, but there are perhaps 30 or 40 of offshoot religions and various very minor religions that are out there, each requesting different accommodations.
But a lot of them, for example, had special dietary situations.
Correct. Dietary issues are always a problem. We're trying to provide inmates with special diets within the confines of a prison, trying to avoid creating jealousies of other inmates.
Mr. McFarland, I'll ask you the same question that I asked Mr. McGalligan. The judge in the Superior Court applied the Turner Standard. If we conclude that Section 4 requires strict scrutiny, were the submissions by the Department sufficient such that we can make a factual determination as to whether or not the Department has satisfied both aspects of that test, both the compelling interest and the narrowly tailored? In other words, I take it that the Department was proceeding on the basis that the Turner Standard would apply, or did you also, in the alternative, say if it's strict scrutiny, we've met that test?
Correct, Your Honor. Our brief does.
No, not your brief here. I'm talking about in the trial court, the factual submissions.
Well, the submissions to the trial court on the various briefs and affidavits certainly put out very substantial security concerns.
So you're saying that if we were to look at those, if we were to conclude that strict scrutiny is required, that you have given the Department has put forward whatever it wishes to put forward, and so we can reach the determination?
Yes, Your Honor. We certainly believe that issues that raise security concerns within the prison reach the compelling interest standard. For example,
I heard Mr. McGalligan essentially saying, of course that's a compelling interest. The question is whether or not it's narrowly tailored. And so, for example, just by way of one example, there's apparently a limitation on the oil that is used for this religious ceremony. The Department doesn't challenge that oil is required, and yet there appear to be other ointments, shampoos, and other kinds of things that are permitted that have no religious use. And so if one were looking, yes, there are legitimate security reasons. Is it narrowly tailored? Doesn't appear to be when you can have shampoo as opposed to prayer oil.
well, if I can address that, Your Honor, I believe that prayer oils themselves have become a special commodity in prison because they are very pungent.
Is this in the record?
It's in the record, Your Honor. And there are evidence of inmates selling the oil, excess oil to their friends. There's evidence that they use
For
it
purposes of what?
for
Covering up
purposes
smell?
of covering up smells in the cells. They're smoking cigarettes. They're doing marijuana. For purposes of preparing
That's
for
in the
a
record?
date.
Is that in the record?
It's in the record, yes, Your Honor. There are a number of affidavits
Was that
discuss.
challenged?
I don't believe it was challenged. So we fairly...
Will we, if we look at the affidavits, I mean, I take it that they're counter affidavits?
Yes, there are affidavits, and there are also some deposition testimony that clearly shows that the attempt to limit it to 1 ounce for 3 months is to provide the inmate with the access to the oil, and our imam, which testified in the record, says that 3 months should be enough. Well, 1 ounce of oil will last 3 months if it's used moderately. If you pour it on your head every night, it's not going to last that long. But by providing with 1 ounce for every 3 months, there's oil for the prayer services, and yet you're also able to prevent an inmate from having excess amounts where he can sell to somebody else or use it to get out of his cuffs by making his hands slippery, or put it on his floor to make his floor slippery to avoid officers going into his cell and perhaps trying to restrain him.
So but the bottom line is, without going through everyone, is if we look at the record, assuming that we were to find strict scrutiny, you are comfortable that the record will show both compelling interest and narrowly tailored,
Yes, Your Honor.
and that there will be no disputed issues of fact with respect to that?
I do not believe so. I think it's my brother may quibble over whether or not there is enough anecdotal evidence, but certainly this Court has allowed prison officials to present general ideas, general concerns that they have with regard to security. For example, the issue of the golden magic shaving powder was determined by security staff to have an impact on drug urine tests and also to be used as an abrasive. So they decided not to sell that. Now, Mr. Rasheed could try, if he's got a medical condition, he could try and go to a doctor and find some other solution for his being able to shave his face. But certainly, the gold magic shaving powder is not a religious requirement, a religious item. It just helps him shave.
I take it you have, it's already come up, you have religious experts in this religion who advised you on all these things and said what you're doing is appropriate.
Correct, Your Honor.
Now, there is, of course, that strand of law, case law, that says it's more dependent on a person's own view of the religion. How do you square those two things?
Well, I think in this case, we're not talking about idiosyncratic concerns by Mr. Rasheed. He talks about a prayer towel. Now, we have two experts that say the need for the prayer towel, the prayer rug, is strictly to keep the individual off the dirty ground, the dirty surface. And that's all you need. It's to provide comfort for the knees and keep him off the
So it's not a situation where the inmate can say, that's not good enough for me. Now, I imagine no alcohol is allowed in prison.
Correct.
So a Christian or a Catholic who says, I can only take communion by drinking the wine, wouldn't get it.
Correct.
Or would get it or would get it,
or grape juice or whatever.
or would get it in carefully controlled circumstances. That's a little different because the priest gives it or whatever.
But your religious expert, your Catholic expert, Christian expert, whoever it might be, would say that'd be all right. Grape juice is fine.
Correct. And that's what happened in this case. The prayer towels were said by both experts. They serve the same purpose as the prayer rug.
Are they kept separately? Are they washed with the general population's laundry? Or?
Well, no, the inmates are allowed to wash them by hand in their sinks. So if there's a concern about it being impure, each inmate can wash it on his own in the sink at night.
Is that in the record, too?
I believe that is in the record, that there's talk about that, because they can do that. Now, with regard to the issue of the basin for his washing his feet, our position was that you can do your ablutions very easily. Just sit on the bed, get your washcloth with soapy water, and you wash whatever you need to do. Sitting on your stool or your bed.
Let me ask you this. There are two things. One is size 18 feet are large feet. And it's undisputed that he has size 18 feet.
Correct.
If one is looking at narrowly tailored, and again, I haven't looked at the whole record, there appear to be other situations in when inmates have basins or buckets or mop pans. I mean, that is to say, when one is looking at these religious interests, there's no question that you need to wash your feet. Is there some peculiar reason that the department advanced why this particular kind of basin versus any other kind of basin presented a security interest?
Your Honor, it's all a matter of keeping the minimum amount of property in the inmate's cell. The more property there is in the cell...
No, I understand that, but if you let some inmates have some basins, doesn't it appear as if this might be an attempt to target somebody improperly for their religion?
Well, no, I would disagree, Your Honor. I would say that if an inmate has a foot problem and he has to soak his feet in Epsom salts or whatever, they provide him with a foot bath.
And why can't he do that in a basin?
Well, I'm not sure, Your Honor, but for example, with Mr. Rasheed, he can easily fill the sink in his cell with water, washcloth with soap, sit down, take off his socks, and wash his feet. He doesn't have to put his feet inside the basin. He can sit down and he can also at the same time wash his hands, his face, using a washcloth.
And
So
once
really-
again, the expert says this is all right?
Correct. And there's no need, in fact, Mr. Rasheed admits that there's no religious significance to his foot bath pan. It's a matter of convenience for him.
Can I ask you, I take it in this case, there's no religious land use and institutionalized persons act claim?
Correct.
RLUIPA.
RLUIPA, yes, correct.
There was in the other case. Does that make a difference?
Well, it does and it doesn't. I mean, we raised under the PLRA, we had challenged the federal claims, feeling that he failed to exhaust his remedies. So, in this case,
You
we had
raised the same
raised
issue here.
RLUIPA. We raised PLRA failure to exhaust in this case regarding his federal claims. if he'd raised the RLUIPA case, that would also fall under that exhaustion requirement. But
Doesn't it
otherwise-
also create a higher standard, or would you say the standard created in that statute is the same as the Turner versus Safley standard?
Well, the Supreme Court just recently ruled on that in the Cutter case and said that it was a compelling interest standard. However, the Supreme Court did make a point to say that courts need to be very mindful and very deferential to prison authorities, prison policies that attempt to maintain security and order within a prison. So it's not quite clear, but I do believe that the court has stated that you really have to balance, even a compelling interest, you have to balance the needs of the prison and look at their policies and the fact that they need to be applied to. I mean, this court in the MassPac case indicated that the strict scrutiny standard applied to a prison case would seriously hamper the ability of prison officials to anticipate security problems and develop solutions. That is our concern.
I know, again, I don't think that anybody's suggesting that security is not a compelling interest. And there we were dealing with different articles of the Constitution and also the specific requests that prisoners were making.
Yes, Your Honor, and I think we have to deal with situations like, if you look at the case of the standing counts, I mean, the record's very clear that the standing counts are 4 times a day, very specific times, 7:10 in the morning, 11:10 in the morning, 4:30 and 9:30. And the record also shows there's like an hour and a half, 2-hour period in which Mr. Rasheed can do his prayers. A very long time period. In fact, when the sun rises is when he can begin his first prayer, which is way before the count. So in some cases, it wouldn't take much to solve everyone's problem by just having Mr. Rasheed do his ablutions and his prayers half an hour before the count, half an hour after. But if you're sitting there in your cell and you're waiting for the count to start, then you start your prayers, well, you've got a problem.
Well, do the counts occur at any religiously significant moment?
Not from my understanding, Your Honor, because the record shows that there are like an hour and a half, 2-hour time periods between each prayer session.
For instance, in the Catholic Church, bells are rung in certain churches at 6 o'clock in the morning, at noon, and at 6 o'clock at night.
If the count was at 6 o'clock or noon, it would...
Is there any religiously significant moment of the day that happens to coincide with the head count?
I don't believe so, Your Honor. Certainly not in this case, where the periods for the prayers are very wide.
And once again, your expert has cleared this, has said, look, he can do his prayers at times conformably with the religion, at times other than the head counts.
Correct.
In this record?
Pardon?
In this record?
In this record, there's plenty of information that sets out both the times of the counts and the time periods that are available for each Muslim in the daytime. There are 5 different periods with each names. Each has a different name, starting at 3:30 in the afternoon, going till 7:30 till midnight. The morning one is from sun up to maybe 11:30. So there's quite a wide range of time period in which one can do his prayers and not have any conflict with the standing counts, which are extremely important to security for staff, to know who's in the cell and that the officers, that the individual inmates is not in any kind of injury or in peril.
Can I get back to RLUIPA just for a moment?
Yeah.
Hasn't RLUIPA changed everything on the federal side? And why doesn't that really apply to us as well?
Well, the Federal Bureau of Prisons has been under effect of RFRA since the 90s.
Excuse me, I'm going now.
RFRA was the Religious Freedom Restoration Act, which was overturned by the Supreme Court in the Bernie case.
Right.
Well, that only applied to states. So, in a sense, RFRA still applies to the federal courts, which has a similar standard to
Doesn't
RLUIPA,
apply to the states?
It does.
But there's no claim here.
There's no claim for RLUIPA here. And as you know, RLUIPA is also being challenged in a number of states.
But RLUIPA applies. For instance, the other case we had here, very similar, has a RLUIPA claim.
Yes.
And all I'm trying to understand is, hasn't RLUIPA changed the standard to, in essence, a strict scrutiny standard?
Well, not necessarily. The problem is that most of our concerns that we raise when we're dealing with inmate property items or religious property, we do look at security concerns. That's the foremost reason. To the extent that security concerns reach the level of a compelling interest, we are covered.
You're covered with the first part.
With RLUIPA.
Yeah, but certainly we feel that, as this court said, it's...
Yeah, you can't, under RLUIPA, you can't impose a substantial burden on the religious exercise of a prisoner unless it's in furtherance of a compelling interest, and it's the least restrictive means of furthering the compelling interest.
Correct.
Sounds very close to strict scrutiny to me.
It does, Your Honor. And
that now applies to all federal prisons, and I assume it applies to all state prisons that, what, get federal aid? Or?
Yes, it applies to this prison, Your Honor.
Okay.
But I would say, Mr. Justice, that the court in the Cutter case did make clear that courts in applying RLUIPA need to be extremely mindful of the difficulties and provide some deference to prison authorities. So it's not clear how that's going to shake out and what standard will come down as to...
But it seems to me that Turner versus Safley then is really off the table when it comes to the exercise of religious rights in prisons. RLUIPA controls.
To some extent, but we still have the state statute, 127, Section 88, still applies in state cases, and that would be the rule.
Very good.
Thank you. No other questions?
Thank you,
Thank
Mr.
you.
McFarland.